Hello and welcome to this tutorial on buying and selling real property. It does not cover absolutely everything we discussed in class or vice versa, but together our coverage in class and this tutorial should really help you nail down the essentials every lawyer should know about standard residential real estate transactions with a little bit of commercial real estate law thrown in. The basic transaction starts with the signing of a purchase contract, enters the executory period, and ends with the closing. Nonetheless, some legal issues arise when the negotiations even begin, so I'm talking about the duty to disclose, and these issues are particularly acute when a real estate broker takes a listing and advertises the home for sale, and when a real estate broker starts to take a buyer around to shop for houses. So first I'm going to show an overview of the major steps of the transaction with key issues, and then I'm going to talk about brokers before continuing. I posted an example of a purchase contract I customized for one of my sales, as well as a standard form contract used in Boone County by Sibsey Klein. I walked you through the key provisions of those during class. Here on this slide, I have an overview of the three major phases of any real estate transaction: the purchase contract, the executory period, and the closing. Nonetheless, there may be some legal issues that arise before the purchase contract is signed, like I mentioned. So if a buyer uses a realtor, the real estate broker has form contracts designed by the brokerage's lawyers. The broker will work with his or her client in order to fill in the blanks. Those will be the essential terms, and then that will be submitted to the seller to make an offer. I posted an example of this. You could see that on my example, the deal went through a little bit of back and forth. So there was a counter offer that was made simply by altering those terms on the form contract, the price. Once a deal is struck, both the buyer and seller are in the purchase contract. The buyer needs to come up with earnest money, which in our part of the country is typically a low amount, about $500 or $1,000, maybe two. The realtor will put that into an escrow account and it will be used towards the ultimate purchase price. Immediately thereafter, when we have a signed deal, the executory period will begin. And that is when all of the conditions of the contract are to be satisfied. Once they are, the parties will go to closing. Now, I don't mean to imply that every single real estate deal will have a purchase contract that's signed. As you know, although the statute of frauds applies, and it should be, there are some ways around it, and we'll get to that later. So at the closing, the buyer has to come up with the purchase money, which most of us need a mortgage to do. Banks and other lenders typically require someone to have a down payment to get the mortgage. Back in 2000, you could get a mortgage with practically none of your money down. Now in 2016, you need some money. So my place that I'm in now, I put down 5%. I took out a first mortgage and a second mortgage. That's a very common way of doing this. But the standard mortgage conceived of throughout the United States is a 30-year loan with 20% down. But lots of us buy them with far less, and not all of them are consistent throughout the 30 years. There's what's known as an adjustable rate mortgage, which lots of us use in order to get in with a low down payment and a low monthly payment to begin with. But the danger of that is that after a certain number of years, as agreed to, typically 3 years or 5 years or sometimes 7 years, then the mortgage interest rate is going to adjust to coincide with the market in some way, often with a premium. So it's risky, and that's part of what got us into the whole foreclosure mess to begin with. Nonetheless, at the closing, the seller needs to produce marketable title. If the seller has a mortgage, the escrow agent managing the closing will make sure that it is paid off with the buyer's money, including the buyer's mortgage money from the bank. And this is the same for any other liens against the property. The closing agent will make sure that all of the conditions in the contract are satisfied and release the signed deed to the buyer and the cash to the seller, at least whatever remains after paying off the mortgage and any other liens. If there is no cash left over and the mortgage exceeds the purchase price, then the seller is said to be upside down. That means the seller will need to pay some money in order to close. Alternatively, the bank may agree to take less than what is owed on the mortgage. That's what's known as a short sale. Or the bank might accept the deed and agree not to foreclose against the property. That's a deed in lieu of foreclosure. That means that the seller can get out of the agreement with the bank to pay back the mortgage without ever even finding a buyer. And we'll talk more about those things when we cover foreclosure in a separate presentation. Now, for a standard form contract, I walked you through it and I showed you key provisions. But here are the things that are normal for any good form contract. The purchase price and how it's going to be paid, including the amount of cash required down, any planned financing, what type of mortgage is going to be applied for, what the maximum interest rate will be that the buyer needs to accept, and the length of the mortgage. We need a legal description of the property. Really, the street address is not adequate. The survey of the property should be attached to show exactly what parcel is being purchased. We need a promise, right, a warranty that good title will be furnished by the seller, as indicated by an abstract of title, certificate of title, or a policy of title insurance. And then there are warranties of title in the purchase contract, including, it should include, title restrictions and any other rights and limitations to which the title may be subject, such as homeowners association restrictions. It should contain the date of transfer of possession. It's going to state that utility bills, property taxes, and other similar expenses will be prorated. It should state which party will be responsible for the risk of loss pending closing or transfer of possession. It should have an itemization of any furnishings, appliances, shrubbery, air conditioners, or other personal property and fixtures to be included in the sale, basic terms of an escrow agreement, and provision for return of initial payment if the sale is not completed, and signatures of the parties. Realtors are the norm throughout the country. They get listings which belong to their brokerage, such as Sibsey, Klein, or Century 21, and then they are paid in commission when the house sells. If the brokerage's agents found both the seller and the buyer, the brokerage gets the entire commission. If a different brokerage brings a buyer for a brokerage's seller's house, both brokerages split the commission. Standard commission for brokerages is 6% throughout the country, although RE/MAX charges 7% and plenty of people pay it. The commission comes off the top of the sales price. Then how much the individual realtors get paid is a matter between the brokerage and the realtors. There are now lots of flat fee MLS brokers out there, so they don't show houses or that sort of thing, but you pay them and they will list your home on the multiple listing service, which is what drives Realtor.com. In my experience, decent service starts at about $450, but they may go as low as $99 for some bare bones listing. If someone sells a house using a flat fee broker, he or she or the buyer will either need to draft up a purchase contract themselves or hire a lawyer to do that. So when it comes to these brokers, they're supposed to exercise fidelity and good faith towards their clients. They're supposed to not have conflicts of interest, but what amounts to a conflict of interest is different from jurisdiction to jurisdiction. The usual way this works out is that the broker is a fiduciary for the seller, no matter who that broker is dealing with. If they're driving around potential buyers, they are usually fiduciaries for the seller, so it's important to find out. On Twin, I posted an agency disclosure statement for the seller. So this is a form that many realtors will use in order to explain who they represent and what their obligations are. So as I mentioned before, most of these, especially locally, say that the brokerage is a fiduciary for the seller, regardless of who they are driving around and showing the home to. Now, there are a couple of different types of listing agreements. One is open. That means that the seller is hiring a real estate broker to help sell the home, but the seller retains the right to sell it through his own efforts or through a different broker. So there is no guarantee here at all that when that house sells, that the real estate agent who took the listing will in fact get a commission if the seller sells it through either a different broker or on his or her own. This is a little risky in that it could lead to litigation. So if the realtor brings somebody through the home and then the seller tries to make a deal with the person who walked through the home with the broker's help and bringing them there, that's what leads to litigation in this scenario most often. Now, another common way is that we have an exclusive agent. The agent is the sole person with the right to sell the property for a specific period of time. Really, I should say the brokerage taking the listing is the sole entity with the right to sell for a specific period of time. If the agent doesn't sell within that period of time, well then the seller and the agent can decide whether they want to extend that agreement or not. Then we have exclusive right to sell, which means that the agent gets a commission regardless of who finds the buyer, as long as the property is sold. It's sort of like exclusive agent with no time limitation. I have just a little bit more that should have been on the last slide, but for some reason I can't attach it. So behind the agency disclosure statement that brokers provide to sellers, which I have on Twin, you'll see the form that they use for buyers. So they disclose to buyers that they're driving around and showing homes. This is who I represent. If it's the same brokerage that's representing the seller and the buyer, they're going to have to represent that and that they're in a dual agency. And most buyers don't see this until they sign off on the purchase contract as an offer to go ahead and send it over. So most buyers don't realize when they're driving around with the agent that most of them are in fact agents for the seller, even if they do ultimately bring the buyer to the table and have some obligations to them. And then finally, I show you the example of the form in a little bit different format because it's created by different lawyers for RE/MAX, just so that you can see how this type of thing works. So with that, I have on this slide just the major issues to think about when it comes to purchase contracts, and I'm going to touch on each of them as we go forward for the rest of this presentation. This slide gives you the requirements for what needs to be satisfied to comply with the statute of frauds. Deeds and real estate contracts must be in writing. They must be signed by the person who someone is trying to bind to the contract. The writing must include the identification of the parties. It needs to have a sufficient description of the property. It really should have the plat map attached to the back. It should have the price or a method to determine the price, or a formula perhaps by square footage or whatnot. And it needs to clearly express that the intent of the parties is to convey the property. And then in class, and the book touches upon the Uniform Electronic Transactions Act and the e-Sign Act, but I don't think we need more on that here. So when an agreement doesn't comply with the statute of frauds, in other words, we have an oral contract or something that's less than a complete writing, there are some ways around. The first is part performance, and the jurisdictions are inconsistent in exactly how these three elements need to combine. Most jurisdictions say you need to have some combination of the three, but they differ a little bit in what combination exactly you need. So 2 out of 3 might suffice, but typically you need at least one of the first 2. So part performance should apply if the buyer has already taken possession of the property, paid at least part of the purchase price, and or made improvements to the property, so that it would seem unjust to not enforce the contract and the buyer has already put in all of this time and energy in order to go ahead and become the buyer of the property. So the case that we have in the book talked about part performance, but it really wasn't a part performance case. It really was an equitable estoppel case. Equitable estoppel kicks in when one party acts to his detriment in reasonable reliance on the agreement that there was going to be a sale of this home. Typically what that means is that the buyer sold his or her own residence in order to move into the next home. And the other aspect that's required for equitable estoppel is that serious injury would result if performance is refused. And a lot of courts apply quite a high standard for what is serious injury. It's not just about money. So most of these cases, somebody already sold a house in order to move into the next one they had agreed to buy. So marketable or merchantable title is what the seller needs to provide by closing. And here is the definition for marketable or merchantable title. A title not subject to such reasonable doubt as would create a just apprehension of its validity in the mind of a reasonable, prudent, and intelligent person. One which such persons, guided by competent legal advice, would be willing to take and for which they be willing to pay fair value. So let's talk about some examples as we get into the next slide. I already mentioned that this standard of title needs to be delivered by closing, but if it's clear early on that it can't happen by closing, the buyer's going to be able to get out. So the first example is the seller's property interest is less than the one she purports to sell. So if the seller has promised 40 acres and a mule but only has 25 acres and a mule, then he or she is not going to be able to deliver the full 40 acres as promised. So that's a pretty clear example of less than marketable title to the property as promised. Another very common example is that the seller's title is subject to an encumbrance. So an encumbrance might be an easement, and if that easement is not disclosed in the purchase contract, or if somebody else out there has the ability to file a reasonable quiet title action as to part of the property, perhaps because of an easement or an adverse possession grounds, then that's a reasonable doubt as to whether the seller can actually deliver marketable or merchantable title. So an encumbrance is an easement, or that might even include homeowners association regulations that apply to the property, but it does not include governmental regulations or zoning as to what you can do with the property. Another common example that comes up as to the seller not being able to deliver all that's promised is if the seller is married. The spouse very well may have an interest in the property that cannot be transferred without consent, such as dower or homestead rights, or if the property is community property. This is true regardless of whether the spouse is named on the deed, as you might expect for marital property, especially if it's held as tenancy by the entirety. The deed may not reflect that, and the purchase contract may not. Also, if you represent brokers, the broker should make sure that the contract states the seller's marital status. Otherwise, the broker might be liable if there is a spouse who won't sign at closing. Now, as I mentioned, these homeowners association restrictions are technically encumbrances, and if someone's driving around and looking at homes in the burbs and you see in this neighborhood that everything's 2 stories or everything is set back from the property line or by a certain distance, or there's 50% brick on every single one of the house, or there's only certain types of fences and all of the houses seem to be of a minimum same size, well then the only reason that all of that uniformity comes about is because there is a homeowners association that applies to this property, and the rules are enforcing this kind of uniformity. As long as that is disclosed in the purchase contract, then the seller is conforming to the obligation to deliver what was promised, and the buyer is not going to be able to get out of the property under the idea that marketable or merchantable title is not being conveyed. But if that stuff is not disclosed, then technically marketable or merchantable title is not being delivered. But as time went on, and lots of us want to live in the burbs, and lots of us want for the phone company to be able to attach wires, and lots of us are fine with cable connections, and even write to the cable company to come and deal with the lines. And we want water and sewage connections. So as a result, the form contracts really should say that those things are acceptable as long as they don't interfere with the use of the property for residential purposes. Because we don't want people being able to get out just because the toilet can flush and actually have the water go to the right place. Now, in the Lohmeyer case, provided that the buyers were accepting absolutely everything. And the key to remember is that people are signing off on these forms to make offers before they usually have any idea of what kind of restrictions might apply to the property. So I think it's much wiser that the form contracts should say that there is some escape hatch if there's some sort of material restriction that interferes with the ability to use the property for residential purposes, but not just for everything, because most people are perfectly fine with that. So in some jurisdictions, this is a minority rule, the rule is such that if the buyer knows about an encumbrance, such as when it is visible, the buyer is presumed to have impliedly agreed to the burden of that encumbrance. So visible telephone lines have been the subject of a fair number of those cases. If you have a form contract, you don't have to worry about majority and minority rules. You're going to be dealing with the contract's terms. If you are ever drafting a contract for a buyer, I would recommend that it should not be binding until the buyer is given a copy of the recorded covenants and easements and waives them. Another important thing to remember when it comes to marketable or merchantable title is that the physical condition of the property is not a marketability issue, even if it's toxic waste. Marketability is not about whether someone out there might pay some amount of money for property or whether your particular buyer overpaid. Marketability is about having clear chain of title without clouds already or on the horizon in a reasonable way. That's what marketable title is about. Also, you should know that if the contract doesn't mention at all record title, then the buyer is taking a small risk that the buyer could be stuck with the seller's title if it was obtained by adverse possession. And virtually nobody wants to pay anything approaching fair market value for the property as if it came with a valid deed as opposed to not. So this is a pretty risky thing that somebody else could come out of the woodwork down the pike and validly claim the property. So the form contracts should deal with that. The form contracts should say that title needs to be marketable and that record title, in addition to our common conception of marketable title, should be provided. Equitable conversion can kick in when the parties have entered into a specifically enforceable contract for the sale of land that is still in the pre-closing executory period. The doctrine basically means that equity regards as done that which ought to be done. It provides that the buyer is the owner of equitable title at the moment of the date of the contract. The seller has legal title, actually as a trustee for the buyer, and the seller also has a claim for the money secured by a lien on the land. The two red flags to know that you've got an equitable conversion claim on your hand is that the property incurs damage or either the buyer or seller dies during the executory period. We'll start with the risk of loss issue. Under the common law, the risk of loss has typically rested on the buyer during the executory period. Maybe that made sense back in the days where farmers were buying land to farm and building their own farmhouses on the land. But nowadays, very few people would realize that as a buyer, they bear the risk of loss before closing. Most form contracts will provide that the risk of loss is on the seller, which makes sense because it is typically the seller in possession until closing. That's not always the case, however. So you saw in the brush grocery cart case, which was a rent-to-own or installment land sale contract structured as a lease with an option in one document, there was a risk of loss issue that arose because the buyer was already in possession and then tried to trigger the option to buy, and the parties fell out because each side accused the other of engaging in bad faith in bringing their own expert to provide an estimate of what the property was to be worth. So as they went into litigation, the would-be buyer moved out, and this property was in Hale Alley in Colorado, and during the period where they were fighting in court, horrible hailstorm came and did awful damage to the home. The risk of loss is not a remote, impossible thing, especially if you're dealing with an installment land sale contract or a rent-to-own contract that's going to drag on for years. This one was a 5-year rent-to-own contract entered into in 1992, and the litigation dragged on for quite some time, and in the interim, it's not out of the question that there might be damage to the home, or in this case, the commercial property as it lies vacant in particular. So ultimately, the would-be buyer returned the keys and moved out, and the seller even said, "You have to move out or I will treat you as a holdover tenant." So when the land was vacated, the would-be buyer informed the seller that it would not be maintaining casualty insurance on the property. And indeed, if you're not in possession of the property, you wouldn't have an interest to insure, so you wouldn't be able to. So the court adopted the modern trend, which is reflected in the Uniform Vendor and Purchaser Risk Act, where the party in possession bears the risk of loss during the executory period for damage like this that's of no fault of either party. So that's the lesson to be taken away, that in the absence of the contract assigning loss to one side or the other, the majority rule is that the risk of loss is on the buyer. But the modern trend, it's a minority rule, but the modern trend is to put it on whoever is in possession. Now, I gave you some practical advice if you were ever going to do a rent-to-own or installment land sale contract, and I would normally only recommend that for commercial property. But I told you that I did make an exception, and I did it once on residential property. But in any event, the contract should be explicit of who bears the risk of loss, at what periods of time, and who must maintain casualty insurance on the property and for whose benefit. So some of the reasons why I don't like these arrangements, especially in a residential context, is that the tenant buyer views him or herself as having equity in the home, even when he or she doesn't ultimately buy the place. That emotional attachment is not based in law, but often causes complications. Also, if part of the purchase price is going towards a down payment, which is the norm, then exactly what will be returned in the event the parties don't agree and they wind up accusing each other of breach and going to litigation is often not specified. In Brush Grocery Cart, the court permitted the would-be buyer to rescind and recover any payments he had already made. That sounds like every penny that the would-be buyer paid is going to go back to that would-be buyer. That means that Brush Grocery Cart got to stay in that property for years rent-free. There's no way that's what the parties intended, even if there was an option to purchase within the contract. I prefer to have one document that is a lease and one document that is an option. Doing it that way leaves title squarely in the seller until closing, which means the seller retains the tax deduction for itemized taxes. The rent would count as income to the landlord. Of course, if the tax brackets are very different on each side, it might make sense to do an installment land sale contract, but it is considered a sale for mortgage purposes on the date of the signature. So if the buyer records it, it's possible that the seller's mortgage lender keeps tabs on what's recorded. There's a risk that the lender would choose to exercise its right under the acceleration clause of the mortgage loan, which would mean that the whole thing is payable immediately, or else the lender has the right to start foreclosure proceedings. That would be one big mess, landing the seller in breach. So for many reasons, I don't like to combine the two. As I mentioned, the other red flag scenario for equitable conversion is that either the buyer or the seller dies during the executory period. In that event, equitable conversion means the sale will go through, the house will be an asset of the buyer, and the cash will be an asset of the seller. If either has a will that gives the house to one person and cash to another, the property will be treated as a home under the buyer's will and cash under the seller's will. So this is something that maybe some people don't actually expect. Now, on page 564 of the third edition of the book, right before we start to get into the duty to disclose, there's a great paragraph, I think, that explains inheritance that I recommend to you. It also states that in some jurisdictions, any amount still owed on the purchase price, so if we're dealing with a short sale, will be paid out of the personal assets of the buyer's estate, reducing what the seller actually receives. So that's something that's a little bit quirky, perhaps. Now I want to talk about what happens in Kentucky if there is a payout under insurance because there is a loss. Kentucky's quirky in this regard. So let's say that the seller had insurance on the property, but the common law rule putting the risk of loss on the buyer was not altered in the contract. Kentucky lets the seller force through the sale and use the equitable conversion doctrine to stick the buyer with the damaged property, and the seller can keep insurance proceeds. In other jurisdictions, in these scenarios where there's insurance being held by the seller, the court has implied a constructive trust on those insurance proceeds and gone ahead and given them to the buyer so that the buyer has some cash to fix up the property. So that's just one of our local quirks, and every place has its own. Nowadays, we use our forms to clarify a seller's duty to disclose in real estate transactions. There are some duties arising out of national law, such as the need to disclose lead paint and known asbestos, but the vast majority of disclosures arise under state law. The majority rule is that the seller of residential real property is obligated to disclose defects he knows about that are material and that they affect the value of the property and are not known or readily discoverable by the buyer. Many states impose this obligation on the real estate broker too, but the broker often knows far less than the seller because the broker hasn't lived in the place. Litigation centers around what is material or what is readily observable. My practice is to disclose absolutely everything, even minor stuff. I think it's wiser in the long run and shows you've been diligent in maintaining the home. The complete the blank forms conforming to state law typically require disclosure of drainage problems, building code violations, zoning violations, and structural defects. Nuisances might be included in what needs to be disclosed too. In the Boone County purchase contract on Twen, check out paragraphs 11, 13, 14, 15, 16, and 26. National forms deal with lead paint and known asbestos. Lead paint is a problem in homes built before 1978. Final caveat. In most states, the duty to disclose and the forms are not applicable to commercial real estate. So lots of commercial real estate is sold as is. That's becoming more common with residential real estate too since the foreclosure crisis. That's because banks that recovered properties never lived in them, so the disclosure forms do not apply to them. So more and more homes have been purchased under an as-is standard, like the one in the note in the book after Stambovsky versus Ackley. Jurisdictions are split as to their enforceability. There was one in the Stambovsky versus Ackley contract that did not hold up. Note the final sentence in the as-is clause in the book. It states that the buyer may rescind this contract at any time before closing if, in the buyer's sole discretion, he has any concern about the condition of the property. I would much prefer a cap on that time frame. Also, you should understand that even an as-is clause won't excuse fraud or a misrepresentation or a cover-up by the seller. Those things give rise to a separate tort, and the contracts very well could be the damages could very well be higher than what they would have been in a breach of contract action. One other thing on the as-is bit. The reason why the as-is clause is used in the bank's contracts or unlimited in time is sometimes these short sales drag on forever. So the buyer is going to want to get out. But if you're using an as-is clause in an arm's length transaction from a regular seller to a buyer, I would want that time cap. This weird ghost case involved a non-physical defect that arose in upstate New York while New York was still following the caveat emptor buyer beware rule. That meant broadly that the seller had no duty to disclose anything. It was up to the buyer to do a solid inspection to find defects. Nonetheless, the case highlights for you red flags that lead to liability for failure to satisfy the duty to disclose in any jurisdiction, even if something is obviously readily discoverable by the buyer. If there is a confidential relationship between the seller and buyer, a fiduciary relationship such as a trustee, or if the seller actively conceals defects such as by painting over them, or fraudulently creating a dummy ventilation system to fool people, or covering foundation cracks, or if the seller makes a false affirmative representation about something being up to snuff. Regardless of what jurisdiction you're in, any of those things will subject the seller to liability. In this case, the court came down to holding this, where a condition which has been created by the seller materially impairs the value of the contract and is peculiarly within the knowledge of the seller or unlikely to be discovered by a prudent purchaser exercising due care with respect to the subject transaction. Non-disclosure constituted a basis for rescission as a matter of equity. Rescission means the buyer got out of the contract and got to get back the down payment. The court used the estoppel doctrine to prevent the seller from denying as a matter of law that the house was haunted. The court presumed on this motion to dismiss that the house's reputation negatively impacted its true market value. In other words, the buyer agreed to pay full value, but the real value was lower. Fair market value for that house without the reputation would have been higher. So another doctrine that you probably need to think about for a buyer to get out of a contract in a situation as strange as this one might be mutual mistake. But that's a matter for contracts rather than property. Now, today, I don't know that this particular case comes out the same way. Today, we've got the internet. At a minimum, go ahead and Google any address that you want to buy and find out what's gone on in the house. I've also given you some ways to find out whether somebody's died in the house and that sort of thing. So some state court decisions over time started to apply a subjective standard to determine whether a defect was material. So for the one problem in the book posing the question whether a condo buyer told the seller she was buying the unit because there were break-ins at a prior house, that seller very well might have a duty in some states to reveal that a former tenant had been raped in the unit with security in the building, in the unit nonetheless. This buyer might very well find that material. Maybe we need to know some more details to this tragedy. But nonetheless, a couple of rules to pull out of all of this. First of all, this case arose in New York at the time it followed caveat emptor, so there was absolutely no duty to disclose. Nonetheless, the buyer was able to get out because of the special rule that the court created. Further, defects cases, non-disclosure cases, have been about physical conditions. This one extended it to something different. So this something different has been picked up on, right? That's what stigma statutes are about. Stigma statutes arose out of this tension that the subjective case is raised in the law. Many of these statutes expressly state that the seller does not have to disclose certain information, such as that there was a mass murder in the property or that the seller had HIV or AIDS. Megan's Law is a federal law that requires sex offenders to register with local police, and many states require for the info to be made public. In Kentucky, there is no need for the seller of real property to disclose that someone in the neighborhood is registered for a sex offense. But forms commonly include information about the existence of sex registries and that the seller can go find that information him or herself. This is to try to head off liability under a subjective standard in the Commonwealth. See paragraph 9 of the Boone County Purchase Contract on Twin for an example. Here's the merger issue. When we go to closing and the buyer accepts the deed, the buyer is deemed to accept that all contractual obligations in the purchase contract have been met. In other words, the contract is said to have been merged into the deed. The buyer can no longer sue on promises in the contract that are not contained in the deed. So the buyer must sue on warranties, if there are any, in the deed if something comes up in the future. There are exceptions to this doctrine. If there was fraud, that means that the buyer is not limited to either the deed or the purchase contract. If there's fraud, you can sue for fraud, which is going to open up tort damages for fraud, which are typically going to be treble damages in most jurisdictions. There's also a doctrine that if a contract promises collateral to the deed, then we have something separate and apart from the obligations that are merged into the deed that could be sued upon. This merger doctrine is really coming under fire. Courts keep on coming up to exceptions or construing certain promises as collateral to the promises that are merged into the deed. The implied warranty of workmanlike quality, which often omits the term workmanlike, is something that applies to builders and their brokers of new construction. Buyers should probably insist on an express warranty of quality, in other words, in writing, that the building was constructed in a workmanlike manner and in accordance with accepted standards of skill and care. But changes in builders' contracts are virtually impossible to get for a regular residential buyer. So the warranty is implied. You should know that warranties are generally of little use in bringing lawsuits over anything less than a really major defect. A buyer's best protection is picking a good builder. Nonetheless, the implied warranty of quality provides that a developer of newly constructed residential property impliedly warrants that the property is fit for its intended use, living in it. So the developer may be liable even if the developer has no actual knowledge of defects in the houses built. In most jurisdictions, the warranty extends downstream to subsequent purchasers too. The justification for that is that latent defects may not manifest themselves for a considerable amount of time, and an ordinary buyer is not in position to discover those defects. A rule going the other way might encourage sham first sales to a buddy who then turns around to sell to the true buyers too. Some cases have even applied this implied warranty of quality on the part of the builder of new property to subsequent purchasers of commercial property. One of the more interesting aspects of liability for developers and their brokers involves the duty to disclose off-site conditions. As you saw in Strawn, a builder bought cheap land that over time was getting more and more contaminated by a nearby dump that had been declared a Superfund site. CERCLA is the law that includes Superfund cleanup provisions, but the other parts of CERCLA provide for liability for all owners of that land from the date of the original contamination to the present. In 2002, Congress added some protections for bona fide purchasers of that property who made all appropriate inquiries about previous uses of the property and exercised all appropriate care with respect to hazardous substances found at the facility. But there is still quite a risk in buying such property. Further, for the seller, an as-is clause only insulates the seller from contribution liability to the buyer if the defects could have been reasonably discovered and there is no fraud. They are still potentially liable if the Superfund provisions kick in. So we have an entire industry of environmental assessments so that buyers can try to protect themselves. Nonetheless, because the standard means we must inquire whether the inspection and care was appropriate or reasonable, there is still quite a litigation risk in buying potentially contaminated property. And that liability might extend to off-site developments like the one in Strawn. But if people moved in there and the owners of the contaminated site have gone bankrupt or are no longer in existence, they are left holding the bag. That's where Strawn and cases like it come in. They provide that developers and brokers of these developments are potential deep pockets for the people who bought the houses without knowing there was an off-site disaster brewing and contaminating those beautiful homes. So in some jurisdictions, the builder developer of real estate and the brokers helping them sell is not only liable to a buyer for affirmative and intentional misrepresentations, but also for non-disclosure of all off-site conditions known to them and not readily observable by the buyer if the existence of those conditions is of sufficient materiality to affect the habitability, use, or enjoyment of the property, and therefore render the property substantially less desirable or valuable to the objectively reasonable buyer. This will be a fact-specific case-by-case determination, which means there is quite a high risk of not just litigation, but the need for a jury trial. What happened in New Jersey is just like what you see in the Boone County disclosure to try to ward off Miggins Law non-disclosure liability. The New Jersey legislature ordered the creation of a registry of all off-site potentially dangerous environmental conditions, but it even includes overhead transmission lines, underground gas lines, sewage stations, wastewater treatment plants, and more. The form contract simply tells buyers to go check if they want to. It's symptomatic of our saturation of warnings on all sorts of products. We don't even pay attention anymore. The Strawn Court specifically stated that the duty to disclose would not apply to off-site social conditions such as gang activity or drug rehab or a group home in the absence of communication of specific needs, like the woman needing to get out of her old home because of the number of break-ins. So there is potential for this area of liability to grow. Another interesting development is the evolving warranty of suitability for intended purpose, which applies to new and residential real estate as conceived by the Model Uniform Land Transaction Act. Ohio was the first state to adopt this. If you're really interested in real estate, go ahead and Google that to find out a little more. So that's it for this first video on buying and selling real estate. The next video will cover all aspects of the segment in the book on the closing. I hope this helps.